Hey everybody, John Skiba here, and in this video I'm going to share with you two proven strategies that'll help you to win your debt collection lawsuit against a junk debt buyer. But if this is your first time here to my YouTube channel, please go ahead and click subscribe, check off that little bell, that way you'll be notified each and every week when I put out new videos that'll help you deal with your serious debt problem. Alright, let's talk about a couple strategies today in this video about how you can win your debt collection lawsuit against junk debt buyers like Midland Funding, Portfolio Recovery, Unifund. There's hundreds of them out there. But these entities that are alleging that they purchased a debt and now they're suing you, trying to get a judgment so that they can garnish your wages and levy your bank accounts. I thought it might be kind of interesting to give you kind of a background on how I got into defending consumers who are being sued by junk debt buyers. I've probably done about 300 to 350 debt collection lawsuits. I shouldn't say lawsuits, actual trials. Going to trial, arbitration. I've handled thousands of debt collection lawsuits with junk debt buyers. But as far as actual trial work, I've done several hundred of them. And it wasn't always that way in my law practice. When I first started my own law practice, I did almost exclusively consumer bankruptcy, like Chapter 7 and Chapter 13. The issue was I would have people come in, they were getting sued by debt collectors. They'd come in with like a Midland Funding lawsuit, and they wanted to file for bankruptcy. And I would look at the lawsuit, and they're being sued for like $5,000. And I'd be kind of like, I don't want to throw you into a Chapter 7 bankruptcy and all that entails and the consequences that a bankruptcy has for your credit going forward over a $5,000 lawsuit. There's got to be a way that we can try to defend these. And so one thing I did, I found this great book. The National Consumer Law Center puts out a great book called Collection Actions. It's a great big thick book, and you can see it's a lot of, it's not light reading. not many pictures in this book. But I started reading through that on how to defend junk debt buyer suits, and as I read through what some of the defenses were, and I started pulling out some of the cases that I currently had, and I was looking at them like, hey, this is exactly what's going on in my case. The documents don't line up. There's errors here. They're not the original owner, but they're not providing witnesses from the original creditor. All these issues that were leading me to believe, hey, we can defend these. And so that's how I got started. Is I said, hey, let's. I had someone coming in looking for bankruptcy, and I said, you don't need to file bankruptcy. Let's just try to go about getting this resolved through the court process. And we were able to get a lot of these dismissed, help people avoid bankruptcy, and that's how I got into fighting against junk debt buyers. So let me give you a couple strategies. There's two different real approaches that most attorneys who deal with these things on a daily basis, two different approaches that they take as it relates to how to defend these things. And they're actually kind of on opposite ends of the spectrum, which is kind of interesting. But the first approach is really what we lawyers call scorched earth. This is where you're like, hey, I'm going to defend this, and not only am I going to defend it, we're going to make life difficult for the debt buyer, for their attorneys. And this is done a couple of ways. And I should say, these are all ethical ways. You're just using every advantage you can under the rules of civil procedure, the rules of evidence, to be able to defend yourself against this lawsuit. One of the first ways is through discovery. Discovery is the process that's built into the rules where the parties can request documents, they can request information, they can even request depositions. This is oral testimony where the parties can make each other appear and actually have a stenographer there who's typing this all up, or even a video recording of the particular person that they're wanting to interview, and get their testimony under oath and on the record. So discovery is one of the main ways that a lot of people use to put a lot of pressure on the debt buyer. They'll send over written requests for documents. This is called a request for production of documents. They'll send over written questions asking for information. These are called interrogatories. And then there's another tool called a request for admission, where you're just asking yes/no questions to the debt buyer to get them to respond to it. And there are limits to what can be done as far as the number of questions, the number of documents, the number of requests for admissions. But you can send those over to the other side and put a lot of pressure on them to start producing a lot of documents. Most debt buyers don't have a lot of documents. That's the problem with their case and why you have some good defenses. They don't have a lot. So for them to get the additional documents, they then have to go back to the original creditor. Under some of the agreements that I've seen, they actually have to pay the original creditor additional funds to be able to obtain those extra documents. And it's just basically a big headache. You talk to any attorney, the worst part about law practice is written discovery. It's just so tedious, but they have to respond to it. And so one way to do this kind of scorched earth approach is to provide a lot of written discovery. Another one that's very effective is to request to take the deposition of the witness that they intend to use at trial. This is very effective on a couple of levels. One is that you're actually going to get the information that they tend to expect to testify about at trial, way before trial. And in regular lawsuits, that's what we use depositions for, is because we want to get that information and we want to freeze their testimony for that specific time. So if they get into trial and they testify something that was different than they did in their deposition, we can use that to impeach them, to show that, hey, there's an inconsistency here, so we're not sure if this witness can be trusted or if they're telling the truth as to that particular question. So written discovery, again, request for production, interrogatories, request for admission, and a request to take the deposition of the entity is one way that you can do that. A couple other things you can do. You can request, in a lot of jurisdictions, jury trials. Now, trials can be heard one of two ways. Often a bench trial where it's just being heard before a judge, but a lot of jurisdictions will allow civil jury trials where they'll actually have a jury come in, and you're doing jury selection and requesting the jurors sit there and that they're the ones who decide your case, not the judge. Jury trials can be very cumbersome and they can be very expensive from the plaintiff's position. And often, if a court's going to force a jury trial, you're doing things like depositions and that, particularly if the case is not a whole lot of money. I've seen situations where the attorneys for the junk debt buyers have actually just dismissed the case because eventually it just becomes not cost effective to be able to press that. And so they end up just saying, hey, we'll back out, or they'll offer some type of low-level like settlement that you can take, and you can get the case resolved that way. So those are a couple of approaches of just being really aggressive and really holding the debt collector's feet to the fire a bit. The downside is, if you're representing yourself, this is extremely time intensive. You're going to have to put a lot of time into this. This case will take over your life. If you're hiring an attorney, depending on what your arrangement is, like with the legal fees, it can also be more expensive to do this just because there's a ton of work involved. So those are a couple things to consider, but that is a way that you can use to put some pressure on them to just dismiss the case. Now, the second proven strategy that I have used in a lot of cases to try to get these things dismissed and try to win the case is on the other end of the spectrum. And that is, in the background to this, I should say, is that in court, the plaintiff, the debt buyer in this case, they have the burden of proof, meaning they have to prove all the elements of their case. You don't have to disprove anything. You're the defendant. They've got to come in. They've got to prove who the original creditor was. They've got to prove that you had a contract with the original creditor. They've got to prove that a specific dollar amount is owed. And then the big hurdle, they've got to prove that it was actually transferred from original creditor over to the junk debt buyer. If they don't prove all of those things in court, you're going to win your case. And to be able to prove that, they need several things. They need documents. They need witnesses. They may need witnesses from the original creditor. And so you can almost take a position of sitting back and saying, you know what, prove your case, if you can, because I don't think you can. Because often, if you're not requesting all these documents, they don't have them. They're not out there getting them, and they'll often show up to trial and not have sufficient evidence or sufficient witnesses to actually prove their case. Now, I recently did a video on this called Less is More. You might want to check that out. I'll put a link to that down in the comments section as well. But it goes over this in a little more detail about how you need to be careful, because a lot of times what I see people kind of trying to take a hybrid approach. They want to do the scorched earth and request all these documents, but they think that by doing so that somehow they're going to disprove that the debt buyer actually owns the debt. Often more documents is to your detriment, because then they have sufficient information to be able to prove their case at trial. The scorched earth method is really just to be a burr under their saddle a bit, that you're causing a lot of work and it just becomes not worth it to them. But the other approach is you're not asking for anything, because you're saying, I don't think you can prove it because you haven't shown me anything yet that shows me that you can actually establish all the elements of your case. So those are the two approaches. I've used them both with success over the course of my career. Like I said, I've done almost 350 trials against debt buyers, and they can be very effective. So I hope that helps you out. Go ahead and check out some of the other videos here in this playlist on how to deal with a debt collection lawsuit. A lot of different strategies and tactics can help you deal with these junk debt buyers. Thanks for watching today.